प्लास्टिक की लोग काई आनला संभव पंचकोटी वर्तमान हम प्लास्टिक को मारी नहीं नहीं प्लास्टिक पुणी नेबे पुणी आ पूरा कम रोसी छाड़ी मते यार
Embarrasses me. You're all learned people. Can you visit me?
Good evening, ladies and gentlemen. Namaskar. While observing the foundation day of Adhivakta Parishad on this occasion, which is not only the inception of the institution but also continues journey of lawyers of India towards justice, service and nation building. The organization Adhivakta Parishad is not just for service in the courtroom but also it's a commitment to justice, commitment to the society and commitment to uphold the values and rule of law. While observing the great legacy and a historic day of foundation day of Adhivakta Parishad, I welcome you one and all to this auspicious occasion of symposium on a very important topic which we are going to hear from the erudite speakers who have been kind enough to accept our invitation and grace the occasion. I welcome our chief guest, my Lord Hon'ble Justice Dixit, Shri Krishna, Shripad, Honorable Judge, Orissa High Court. I may request my Lord Justice Shripad to the dais. We are indeed privileged and honoured to have my Lord Honourable Justice Ananda Chandra Behera sir. Truly, we are indebted to you, sir. May I humbly request, sir, please adorn the dais and grace the occasion. I welcome you, sir. We are privileged and honoured to have the Honourable Advocate General of Orissa, Shri Pitambar Acharya sir, to be the guest of honour of this evening. May I request Honourable Advocate General to adorn the dais. We have the President of Adhivakta Parishad State of Orissa, Shri Ajit Patnaik. He is on the way, he will join us. May I request the President of Adhivakta Parishad Orissa High Court Unit, Senior Advocate Sri Rudra Prasad Karo sir, to the dais. May I humbly request Madam Pratima Naik, Joint Secretary, Adhivakta Parishad, High Court Unit, Odisha, to join us on the dais. Atithi Deva Bhava, following the great tradition of Aryavarta Bharata Bhukhanda, to pay tribute to Devata with the same value and same honor, may I request Devata Rupi Atithi to light the lamp and inaugurate the function. May I request President Adhivakta Parishad State of Orissa, Ajit Patnaik sir, to on the dais.
सुखं करोतु कल्याणम् आरोग्यं धनसम्पदाम् शत्रुवृद्धि विनाशाय शुभदीपं नमोऽस्तुते अन्तर्ज्योतिर्बहिर्ज्योति प्रत्यग्ज्योति परात्पर ज्योति ज्योति स्वयं ज्योति आत्मज्योति शिवोऽस्म्यहम् अन्तर्ज्योति मनर्ज्योति ज्योतिश्चक्षुष पश्यति सबाह्याभ्यन्तरज्योति तज्ज्योति शिव उच्यते ॐ असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्युर्मा अमृतं गमय ॐ शान्तिः शान्तिः शान्तिः.
Thank you, sir. As a token of love, respect, we welcome once again from the bottom of our heart our honorable dignitaries to the dais, and we thank them for gracing the occasion and accepting our humble invitation. May I request the volunteers to present a token of love and respect and a flower bouquet to welcome our guest on the dais. Now may I request Shri Gyanalok Mohanty, Advocate and Standing Counsel, Orissa High Court, to please come for introduction of our honorable guest.
So I'll be trying to finish it within 2 minutes. In a cleansed evening, I welcome you all in this symposium. My late Justice Dixit Krishna Shripad, my late Justice Chandra Behera, Shri Pitambar, Acharya, Senior Advocate and Honorable Advocate General of Odisha, President of Adhivakta Parishad State, Mr. Ajit Patnaik, President Orissa High Court Unit Adhivakta Parishad, Mr. Rudraprasad Karo, Madam Pratima, Secretary State, Mr. Devasis Tripathi, Secretary High Court Unit, Mr. Jateswar Naik, friends from media, both electronics and print, ladies and gentlemen. As already directed by my lord that we should not waste time, already we are 30 minutes late. Actually, we were supposed to start our program at 6 o'clock. Unfortunately, because of this rain, we have to start it at 6:30. My late Justice Dixit Krishna Shripad, he needs no introduction. Within short span of period, he has earned for himself popularity in our bar. Everybody says that he is just giving illustration of judgments, laws while hearing a matter, and all are saying that he is very thorough in every law. So far as he started his practice in 1989, enrolled as advocate in Karnataka State Bar Council, predominantly practiced in High Court of Karnataka, Madras, specializing in law relating to election, service, agrarian, reforms, banking, etc. When he was he was elevated to the High Court of Karnataka in February 2018. While he was the judge of Karnataka High Court, he was part of some landmark judgments. Just I want to refer those judgments. That is super hijab, online gaming, tweeters, compulsory medicine service, contested probate proceedings, refund of income tax, GST on set-top box, exemption of university from GST, prohibition of blast mining around reservoirs, reclaiming of reserve forest, fraudulent borrowing from banks, etc. Many judgments are there. Since we are running out of time, therefore I am not referring those judgments. I heartily welcome you, sir, in this function. We are very much privileged that your Lordship has given his consent to give a talk on this subject. Now, Justice Ananda Chandra Behera, he also needs no introduction. In 2023, he was elevated to the bench. Started as additional district and session judge in Champua. Thereafter, appointed district judge in Barampur, Jagatsinghpur, Barampur. Also appointed as Director of Public Prosecution. Now, he is also very much popular in our bar. Now he has become a celebrated judge of our Orissa High Court. Any law, civil, criminal, service, MSCT, which law he doesn't know. I also, it is my power privilege that I am attached to his court as the government counsel. I am representing the government there. I saw that he is also saying this 1973 Supreme Court 485. This is the issue. We just refer that judgment. So we are very much privileged to have such type of judges who have graced the occasion as chief guest and guest of honor. Now, my immediate boss, Learned Advocate General, Shri Pitambar Acharya ji, Senior Advocate Orissa High Court. He also needs no introduction, especially the lawyer friends of our High Court. From his student career, he has shown his excellency in leadership. He was the President of Student Union BJP College, Utkal University, completed MA in Political Science from Utkal University in First Division in 1987. He was excellent in debate and oratory. He is having numerous accolades under his belts, such as Ramchandra Bhanjadev Gold Medal, Vice Chancellor Cup from Utkal University. He was recognized as best debater in both BJP Student Union. He has various awards which cannot be counted. Recently, he received prestigious award, Chelitola Samman, one of the prestigious award of our state. Became the Advocate General of our state on July 19, 2024. Throughout his illustrious career, Sri Acharya has been standing counsel for the Election Commission, notable organizations such as Legislative Assembly, Indian Oil Corporation, HPCL, other things. He is known as a constitutional expert and service law expert, advocate not in our state but also in India. I welcome you, sir, in this function. Towards his left, with sitting, is Mr. Ajit Patnaik, Adhivakta Parishad Odisha State President. He is practicing in Khurda. He is a very good trial court lawyer, both civil and criminal law. Today, though there is heavy rain, in spite of that, from Khurda, he has reached here to grace the occasion to preside over the meeting. Now, Mr. Rudraprasad Karra, Adhivakta Parishad High Court Unit President, Senior Advocate. He is belonging to our family. He also needs no introduction. I welcome you, sir. Madam Pratima Naik. Madam Pratima is the Joint Secretary of our High Court Unit Adhivakta Parishad. I also welcome you, ma'am. With this, I take leave. Thank you.
Thank you. Sir, in Odia we say, Matrubhasa Matrubhumiro Mamata, Jahrude Janami Nahi, Taku Jadi Gyani Gunire Goniba, Agyani Rahive Kahi. So before we dive into the subject, with the permission of the chair, may I request Parthasarathi Naik, learned additional government advocate, to recite Bande Mataram in order to praise the motherland. Then we will dive into the subject of this symposium.
Bande Mataram, Bande Mataram, Sujalam Supala, Malaya Jasitala, Sasya Shamala, Mataram, Bande Mataram, Shubha Josna Pulakita Yamini, Pullakusinta Drumadala Sobini, Suhasini, Sumadhura Bhasini, Sukhadam Bharadam Mataram, Bande Mataram, Koti Koti Kantha Kala Kala Ninada Karale, Koti Koti Brujai Dhruta Kara Karavare, Abala ke nomaye to bale, Bahubala Dharinim Namami Tarinim, Ripudala Barini Mataram, Bande Mataram. Tumi Vidya, Tumi Dharma, Tumi Hrudi, Tumi Marma, Twam hi prana sarire, Bahute Tume ma Shakti, Hrudaye Tume ma Bhakti, Tomari Pratima Gadi Mandire, Mandire, Bande Mataram, Twam hi Durga Dasa Praharana Dharinim, Kamala Kamala Biharini, Bani Vidya Daini,
नमामि त्वां नमामि कमला अमला अतुलं सुजलां सुफलां मातरं वन्दे मातरं श्यामला सरला सुस्मितां भूस्मितां धरणी भरणी मातरं वन्दे मातरं वन्दे मातरम्.
Thank you everyone. Now may I request the President of Orissa High Court Unit Adhivakta Parishad, Shri Prasad Singh Advocate, to address the gathering.
My dear friends, ladies and gentlemen, I take this occasion to welcome Honorable Justice Dixit, Krishna, Shripad, and Honorable Justice Behera, who are here with us, and we are fortunate that they have agreed to address this gathering. Mr. Advocate General Shri Pitambar Acharya, I welcome him, our State President, and all members of the Parishad. It's a great pleasure to have eminent speakers who are well-known debaters, and as the evening progresses, I think the August gathering would agree with me that we have had a very, very meaningful session. So without standing before you and interrupt my lords to speak to you to the heart's content, I don't want to take much of your time. Once again, I welcome all of you and our learned dignitaries on and off the dais. Thank you very much.
Thank you, sir. Sir, before I invite our guest of honor to address, with the permission of the chair, may I request Honorable Advocate General to felicitate the chief guest of this evening. And Honorable, may I request... we're cutting it short. Let's wait. Yes. May I also request Honorable Advocate General to felicitate my Lord Honorable Justice A.C. Behera. May I request the President, Adhivakta Parishad, Odisha, Shri Ajit Patnaik ji, to felicitate the Honorable Advocate General. Thank you, sir. Now I would like to request the guest of honor, who is an outstanding advocate. As we all know, he has got multifaceted designation and recognition. I did not introduce him once again, as you have been elaborately introduced. He has been introduced by Sri Mahanti, but I must say that he is the true leader of the bar and who is the most sought after lawyer and advisor for the state of Orissa, none other than the leader of our bar, the Advocate General of Orissa. May I request Honorable Advocate General of Orissa, Shri Pitambar Acharya ji, to present the keynote address and introduce the topic.
Honorable Chief Guest of this evening, Mr. Justice Dixit Krishna Shripad, Honorable Mr. Justice Chandra Behera, President of Adhivakta Parishad Odisha, Shri Ajit Patnaik, Secretary and my dear colleague Shri Devasis Tripathi, Senior Advocate and President of the High Court Unit of the Parishad, my elder brother Shri Rudra Prasad Kar, Madam Naik, my senior colleague and a present member of the State Law Commission, Shri Surya Prasad Chandra Mahapatra, Senior Advocate Shri Anup Bose, Shri Surendranath Kara. So many distinguished persons are sitting in my front. I am begging excuse not to take the names individually, but a good evening to all of you. Day before, when Devasis called me, I call him Devasis because I treat him as my own brother. So without thinking for a moment, I told, yes, I'll be there. But a month back, I had given commitment to another organization, a literary organization in Sharala Sahitya Sansad, to give away some literary awards to some of the distinguished literatures of the state at the same time, 6:30. It's already running behind the schedule. So I requested the Sharala Sansad organizers kindly excuse me for half an hour. So since I have a commitment which is more professional, so I have to be there. So I'll be late by 45 minutes. I know, as already stated by two of my previous speakers, we have a very, very powerful orator and speaker today in our midst, Justice Dixit. And no less is Honorable Justice Behera. The topic is very apt, and I am sure with their usual erudition, the whole audience would not only be thrilled, but that would definitely send some eternal messages to the entire legal fraternity. So I sincerely do not want to stand as a barrier between the chief guest of the evening, Honorable Justice Dixit, and my dear colleagues seated in front of me. But one thing, in a very precise note, I may make my point very clear. I was going through the brochure which was kept in front of the guests, that the Parishad was established with the avowed intention of creating competent lawyers all over the country. But with all sobriety and humility, I may say, competency is one part, efficiency is another part, legal acumen may be incidental to the professional success. But the most important facet of a good lawyer is integrity and ethics. We say it, there is a saying in Orissa, Thile thau pache guna hajara, charitra nathile sabu ashara. It conveys a very sensible message to the whole society. I have seen poverty very closely. I was not born with a silver spoon. Neither there was any lawyer in my family, nor there will be any, at least. Not my children. I do not know what would happen thereafter. I came alone here, and I am not going to leave any legacy. I will go by myself. But this much I can tell with vehemence, that I stand for one thing in my full and entire professional career, that I will remain uncompromising. There is no question of any compromise with the dignity and ethics of a lawyer, and I have been doing that. It is not a great job, nor I am showing any charity or favor to someone. It's a self-cleanliness process. If I make myself vulnerable, approachable and accessible, people will certainly take you for granted. But the moment the message goes that no, we cannot touch this person, then you make your path very straight. When I am confused, many a time, one thing I had learned from my father in the young days, when you are confused, then you go straight, never look this side or that side, and that is the path. Thanking you very much. I beg apology for all of you, and especially the dignitaries on dais, my two honorable and respectable judges. Since I have a prior commitment, I was requesting Honorable Mr. Justice that I may be pardoned, excused. Whatever language we do use in the courtroom, I am using on this dais. So wherever a judge sits, that becomes a court. So I think that mandamus would not be applicable to me now, and I will take excuse. And since there was a commitment and some literary persons are waiting there, maybe all old men, so you are my family, so there is no formality. So you will all be listening to the erudite deliberations of those distinguished judges of our High Court. I pay my regards. I once again also pay respect to the great person who saved the future of this nation and was the founding architect in giving unto ourselves one of the finest instruments of the world for the governance of this vast subcontinent, that is the Constitution of India. My tributes to Dr. B.R. Ambedkar. Thanking you all. Jai Jagannath, Vande Mataram.
Thank you, sir. Thank you for finding time from out of your busy schedule. Ladies and gentlemen, now it's time to listen from the person we all are waiting for, a man who is a master of law and jurisprudence, a man who is an epitome of dharma, ethics and public life. We know him for his societal concern, spiritual wisdom and timeless value, perfectly coupled with spiritual wisdom and the wisdom to serve the society from socio-economic and judicial side. He is none other than today's chief guest, Honorable Justice Shripad. I welcome sir, and I wish and I invite all of you to give him a huge round of applause to talk on this very important topic, Doctrine of Precedent, and quoting the line from Yudhishthira Yakya Samvad, Mahajana Jeno Gataha Saha Pantha. I welcome you, sir, to address on this topic of Doctrine of Precedent. My Lord Justice Shripad.
Dignitaries on the dais, off the dais, and the participants. Good evening to you. I expected that the function would begin sharp 6 p.m. as was held out to everybody. Anyway, the fall of the rains is a plea of alibi, which it should not happen. Because the founder, Dr. Tattopanta Thengdi ji, he used to maintain the time in such a way He was personally known to me, and he has stayed with me during the last leg of his life, a great intellectual. So much is not necessary to waste again. Coming to the topic, the doctrine of precedent. To know what is precedent, you have to know what are the sources of law. Most of you were present, I assume, when I spoke on previous occasions that there are 4 or 5 principal sources of law. The first one is conventional source, the legislation, legislative process, which you call in English law we call as statutes. In Indian subcontinent, in colonial countries, we call them acts of parliament or acts of legislature. And the subordinate legislation or subsidiary legislation, or in Indian context, which Jain and Jain in administrative law calls as delegated legislation. So legislature, be it state legislature, central legislature like the parliament, is the conventional source of law. You should have the clarity of what is source of law and what is law. A well is a source of water. Well is not water. Similarly, legislation is a source of law. Law being taken in Augustinian notion of law, or Caesar's notion of law, Aristotle's notions of law. Even that aspect is discussed in Plato's Republic, the Epicurean theories. In all these things, we can say law is nothing but a body of rules that regulates the conduct of people inter se, citizen and the crown. And sometimes in federal states like this, it may be states on the one side, state on the other side, state and the center on one side, state and states on the other side. Whatever it may be, Jalan Trading Company, etc., which Shri discusses in his 4th edition. So legislation is over. Number 2, custom is also source of law. Legislation arises from the state, from the legislature. The custom arises from the society. The government, as you know, Harold Lusky, the great professor of Manchester University, he said that state is formed because of wickedness of men. The society is formed because of goodness of men. That's how he describes in his famous books like ABC of Politics and Grammar of Politics, 2 famous books which he has written. He says these things which you can verify from the book. Then we go to the contract. Contract is also a source of law between the parties. What is contract? What is agreement? What is consideration? What is defeating the objects of law, defeating the policy, state policy, etc., which you have seen in best books like Farmston, Cheshire, and Fifoot, and Chitty on contract of law, and Frederick Pollock and Mullah on contract, Indian Contract Act. If you see these things, you will have the broad idea, because that is whole contract is founded on the principle pacta sunt servanda, that what you have agreed to, that you should abide by. That is like you should not withdraw from your words because other person has acted upon it. It is not like just estoppel. You have to make difference between estoppel, res judicata and precedent, which I will come later. So contract is also a source of law. If there is any dispute relating to the parties, we will say what is the arrangement between you. Because that arrangement will be governing the relation between the transaction between the 2 parties, and often Mr. G will say court cannot rewrite the contract, etc. Because contract is the law made by the parties themselves, because law permits it. Other three is over now. Then fourth one is the precedent, which is very larger topic. Much of time is spent in formalities and singing and worshipping this, that, etc. Anyway, that's all right. The doctrine of precedent is a huge subject. Many books are there. Of them, two important books I am quoting. One is Precedent in English Law by Rupert Cross. He happens to be one of the great authors of Law of Evidence also. Rupert Cross' book on precedent in English law is followed in most of the colonial countries, more particularly in UK. Precedent in Rupert Cross means he is cited, like we quote Palkiwala, Shirwai as authorities. The English courts quote Precedent in English Law by Rupert Cross. When we say precedent, before that I will say there is one more source of law, that is the opinio juris, opinion of great juries. In modern law you have seen the hadith, the way the great people in Islam conducted themselves, that becomes law. Or great people, when they opine something, that becomes law. In Indian context, if I want to give an example, when Nobel Prize was awarded to Mother Teresa, the question arose before the government of India whether it should be taxed or not, if at all, or it should be exempted from income tax. Income is defined under the Income Tax Act 1961. Earlier we had 1923 Act. The question arose before the government because the huge money came to the pocket of that saintly lady. Palkiwala said, the question of exemption arises where income is taxable. If the income is not taxable, the question of exemption does not arise. That opinion was treated by the government, union government, as the opinio juris, opinion of juris. Juris opinions are taken as the law itself. Shirwai, H.M. Homi Shirwai, the great author of Constitutional Law of India, 3 volumes, 4th edition, he said nobody should edit the next edition for the period of 50 years. He did not permit that his book should be edited by anybody at least for 50 years after his demise. Therefore, it has stopped at the 4th edition. Shirwai's constitutional law was being quoted when Shirwai was sitting in the court hall, and Shirwai's books will be quoted. This is the opinio juris. Palkiwala, Kanga and Jamshedji Kanga and Palkiwala on income tax. His handwritten book, because it had not yet gone to the press, these handwritten books were quoted before the income tax tribunal as the law. This is the source. This I am saying as opinios juris. Giving this brief, very brief, the bird's eye view of the sources of law. Now I am coming to the topic of precedent. As I said, in English context, in colonial countries context, the Precedent in English Law by Rupert Cross happens to be one of the finest treatises. And in Indian context, there is one book, of course, it is not that great, but you can just read it, by Professor Lakshmi Kanta, Precedent in Indian Law. You can just see it from your Google. The books which I am referring, the decisions which I am referring, just you can quote. Of course, I know that my speech is being recorded so that I can be confronted if there is any mistake. What is this precedent? Precedent in Gautama Sutra is called Purva Nirnaya. It has two meanings. One is res judicata, predicata. The doctrine of res judicata predicata is one. It is already decided between you, therefore you cannot reopen it. Section 11 of the CPC, the doctrine of res judicata, restrictively enacted by the Parliament in 1862 CPC, 1908 CPC and 1976 amendment, with a little broader outline, because constructive res judicata is also enacted. Parties are persons claiming under the parties. Decision on adjudication. Adjudication by the competent body, competent court or competent tribunal, competent authority. Whether res judicata applies to the judicial function or not is another aspect. There is another cousin of this, estoppel. Section 114 and 114 capital A, 115 of the Indian Evidence Act 1872. It stands on a different footing. It is not res judicata. It is something you make a person to believe certain thing. He acts upon that belief and alters his position to his detriment. Thereafter, the person who said something is not permitted to contradict the same. One illustration, the best illustration which is taken from Bombay High Court, is written in that 1872, the Evidence Act, Indian Evidence Act 1872, under section 115. A tells B that I am the owner of the property, I want to sell it to you. B enters into an agreement, and thereafter he did not want to execute the conveyance, therefore B went to the court. There A contended, when I entered into agreement, I was not the owner of the property, but I became owner subsequent to agreement. Court said the doctrine of estoppel is not founded on truth, it is founded on rules of reason and justice. Doctrine against prejudice, etc. There is doctrine of promissory estoppel. It is a bit different from estoppel. Estoppel operates in civil law, and estoppel operates to some extent in criminal law also. 1962 Supreme Court. Even res judicata applies to criminal proceedings. There are such judgments. Now, the doctrine of legitimate expectation is another aspect of that. In the light of these things, you should understand we should understand the doctrine of precedent. Precedent means what has already happened in a given circumstance that can be duplicated in the similar circumstance. For example, case is between A and B. A says, I am the divorced wife of B. We belong to the Islamic faith. I have no means of maintaining myself. I have no livelihood means. Therefore, my ex-husband should be directed to pay the maintenance. Section 125 of the erstwhile CRPC 1973. Duty to maintain. Thus, wife, children who are incapable of maintaining themselves. It only enacts whatever scriptures enacted. In Manusmriti there is a shloka which says, very often I quote it, I used to quote it when I was sitting on the family law side. Pita rakshati kaumare, bharta rakshati yavane, rakshanti sthavire putra. The next line may not be that important. The father looks after the child, the girl child. During her childhood, the father, Pita rakshati kaumare, kumari, kaumari. Bharta rakshati yavane, the husband looks after the lady during the youth, and rakshanti sthavire putra, during the evening of life, it is the son who looks after the mother. This is how that particular shloka runs in Manusmriti. If the question arises before the court, which court? It is only the constitutional courts which can lay down the precedent. That also you have to keep in your mind. The high courts under 226, 227, 228, 250. The Supreme Court under article generally 141, 143 also. To some extent there is divergent opinion. Anyway, you can keep it as you want. What has been decided. Now the Supreme Court said in 1985-86, I don't remember the correct year, that famous Shabanu judgment, where 1985 Supreme Court ACR, where the question was whether the word wife in section 125 of CRPC included a divorced wife, because Parliament has not employed the word divorced wife. It only says wife. The contention was, once the marriage is dissolved by divorce, by way of talaq, triple talaq, whatever talaq, then she ceases to be a wife, therefore no maintenance need be paid. In 1960s, Justice Bhawan of Allahabad High Court, 1963-64, I don't remember the correct date, he said divorced wife is also a wife for the purpose of section 125 of CRPC. The same law came to be reiterated or came to be laid down by the apex court, saying that divorced wife is also a wife. Now, what is the principle? Article 141 of the Constitution says, law declared by the Supreme Court binds everybody, whether they are parties or not. The difference is, if you are a party, you are bound by a decision. It is not because of precedent, but it is because of doctrine of res judicata predicata. Because you are a party to the proceeding, right or wrong, you are bound by that. You are not a party, still you are bound. Then decree in rem. You should differentiate between decree in rem, decree in personam, and the doctrine of precedent. Where in 4 jurisdictions, ordinarily the orders for decrees in rem are granted. One is admiralty jurisdiction, another is matrimonial jurisdiction, the third one is probate jurisdiction, and fourth one is insolvency jurisdiction. Section 41, 42, 43, 44 of Indian Evidence Act 1872. If a litigation is decided between A and B to the effect that A is the wife of B and B is the husband of wife, others are also bound by that, because it is a judgment in rem. There is slight difference between judgment in rem and the doctrine of precedent. In doctrine of precedent, a judgment is there. There is due adjudication. Principles are laid down in the judgment itself. Just take the best example we'll take now. Whether the Constitution can be amended, then how amendment? What is the extent of amendment? Permissible extent. Then you go to case 1 of the Bharatiya versus State of Kerala, 1973 Supreme Court, where the Justice Khanna, led by the other 6 members, held Constitution can be amended. Any part of the Constitution can be amended. The preamble is part of the Constitution, therefore it also can be amended under Article 368, subject to one rider, that amendment should not affect the basic structure of the Constitution, because you have a framework. What is basic structure? Again, is a big debate. We need not go into that. There are many books on doctrine of basic structure. The Nation speaks by Parkiwala's article is there, Professor Pathak's article is there, Professor Upendra Bakshi's great article, Constitutional Quicksands of Kesavananda. So beautifully it is said. So when we go to, since I have got very limited time, I was not the speaker was the Advocate General, and he spoke and has gone now, leaving the responsibility to me. Anyway, he said that I should speak to you, therefore I am speaking to you. My mother used to tell me a short story. To get the work done, something has to be given. A boy used to go to neighboring house every day, a very poor family boy. He used to go asking for buttermilk. And there were people who had abundant buttermilk, but they did not want to part away free. They would ask them, tell me, the story of Ramayana. The boy will say, there was Dasharatha king. He had 3 wives, Kausalya, Sumitri, Kaikeyi, and Kausalya's son is Rama. And the other Bharata, though he did not desire, Kaikeyi wanted Bharata to be crowned. The dispute cropped up, and Rama, Sita, Lakshmana went to forest for 14 years, and Bharata asked them to come, but they did not agree. After 14 years they came back, and Rama was again installed in the position. This is Ramayana. And you would get the buttermilk. That way I am telling you, the doctrine of precedent. It's a very huge topic. I need 2-3 hours to speak on that. But anyway, now short period, there will be short interaction also. Therefore, the principle laid down in a given fact matrix by a court of competent jurisdiction, which is of general application to the realm, is called the ratio decidendi. When you are studying doctrine of precedent, few keywords you can keep in your mind: ratio decidendi, ration, that is decision, principle decided, then the obiter dicta, then the passing observation, then judgment silentio or per incurium. These are the general parameters of this doctrine. Ratio decidendi means the principle that has been laid down in a given case. That is called the principle, the ratio, ration. Rupert Cross very beautifully discusses these aspects. Of course, in Salmon's jurisprudence you will find it. Law and legal reasoning by Julius Stone. He discusses this pattern on jurisprudence, also discusses it. Many books are there. Lloyd's jurisprudence is there. Many books are there. Why it becomes important? Why it becomes important? It becomes important because you want to tie the hands of the God. What are these principles? You all know man's nature, which Leviathan author Thomas Hobbes, whom Salmon's jurisprudence refers. In Leviathan he says man is a rascal by nature. Even in the evolutionary process, the elements of rascality have not completely subsided because they are part of bone, blood and flesh. And Ralph Waldo Emerson, the great American thinker, said man is a rascal 2000 years ago. Maybe he was referring to pre-Christian era. And today he is a rascal. Only difference is 2000 years ago he was illiterate rascal. Today he is literate rascal. So when power is held by the rascals, the so-called sober men run the risk of being abused. That should not happen. Therefore, throughout the evolutionary process of man and the society, the care is taken by the right thinking section of the society to ensure that the principles are laid down based on which the disputes are resolved. Otherwise, our state would become a forest, and monkey will claim that it is the king and it would lay down the policy for all of us. A monkey cannot decide affairs of the forest. Therefore, the principles are laid down. All laws in legislative process, I say, the legislators are not sarvajñas. They are not sarvashaktas. They are not sarvantaryamis either. They cannot comprehend what all situations would emerge in a given case. One famous case I will tell you, that is Hedon's case, which Salmon discusses in his 12th edition, Fitzgerald's edition. In Hedon's case, the law was that every ship which carries the sheep flock of sheep will have a cover around it. And this particular vessel did not have one. Because of the tidal action in the Irish Sea, all sheep were washed away. The cargo owner brought an action against the owner of the ship, saying, had he covered his vessel, my sheep would have been protected. Then the court said, the object was not to protect against tidal action, but to protect the sheep from catching the contagious diseases from the sheep being carried in other ships. So the principle came to be laid down, saying a statute cannot be used for the alien purpose. For the purpose for which it is not made, you cannot make use of. This principle becomes the ratio decidendi. What is the point? Suppose the question arises as to the validity of Hindu marriage in southern India, northern India, eastern India and western India. We go to Mitakshara generally in southern India. I assume, I read some judgments also which says Mitakshara is applicable to state of Orissa also, barring one particular part. When we go to marriage, what are the essentials of marriage? The Hindu Marriage Act does not tell you what are the essentials. Vivaha Homa, Saptapadi, tying of Mangal Sutra, and the darshan of Arundhati Nakshatra. These were under Shastric law held to be the requirements of a valid marriage, Hindu marriage. Of course, law has evolved, it is not static, it is changing, law has to change depending upon the change in the social circumstances. Law and social change is another big topic which you will read. The Wolfgang Friedman, there are at least two books, how very beautifully they have been explained. Law in a Changing Society by Wolfgang Friedman. He discusses how law changes in Europe. There is law and social change by Professor Bhatt, the former Vice Chancellor of Karnataka Law University, who is the best author of 2-3 books here, wonderful books they have written. The stress is, what is the principle laid down in a given decision? Amongst Hindus, I say Vivaha Homa, tying of Mangala Sutra, Saptapadi, Arundhati Nakshatra Darshan. If you go to Gautama Sutra, you will find that. History of Dharma Shastra by P.V. Kane discusses this aspect of the matter. Now, the question arises. Suppose if two Hindus exchange the garland in front of the family deity, in the presence of the people, especially relative, friends, kith and kin, does it amount to a valid marriage? Then gradually, whether tying of Mangal Sutra is essential, if other procedures are not, we do not follow Aryan form of marriage at all. There are many marriages we have seen. Duncan C. Direct on Law of Marriages in India, a wonderful book of Paras Diwan. You have seen Mullah Mains, and they also have discussed about that. The question is, the principle laid down in a particular case, which would be of universal application in the same given fact matrix, is called ratio decidendi. And principle can be laid down only by the constitutional courts, not by other courts, nor by other tribunals. Where there are tribunals, branches, various, for example, central administrative tribunals, state administrative tribunals. You can't say, in one case you have decided like this, therefore you should decide this case also. Similar way, you will say it not because of the doctrine of precedent, but because of doctrine of parity or equality. The parity is different. The principle of stare decisis is different. This you should have. Sometimes, how to know what is the principle laid out? How are you going to decide? If one judge decides, it becomes very easy to find out. Wambas test, which someone says, inversion test. He will give A, B, C, D fact matrix. A is removed with B and C whether the proposition would exist. B is removed whether with A and C the proposition would survive. C is removed with A and B fact matrix, the proposition will remain. This is called inversion test. You will feed something and see whether the same proposition stands. Then that becomes the precedent. First test is the inversion test or Professor Wambas test. Got the point? The problem may arise when a decision is rendered by plurality of judges. If all judges have decided together, there is only one decision, we have no difficulty. All are agreed, therefore there is unanimity. This is the principle that has been laid down. There are 13 judges. There are 9-10 judgments. How are you going to decide which is the precedent, which is the ratio decidendum? It becomes very difficult. Many tests. There is Dr. Upendra Bakshi's test also. I will not spend more time on that because you will have we have question answer session also. In Keshavananda Bharati, 13 judges decided. It was so difficult for the 13 judges to decide what was decided in Keshavananda. Chief Justice Shri skipped off his lunch. He asked his steno to prepare the particular principles which have been laid down in Keshavananda. If you see that reported judgment, out of 13 judges, 9 judges alone have signed the judgment. 4 have not signed it at all. They did not agree with the propositions which Shri has given in the last part of the judgment. They did not agree. 9 judges agreed. Then the question is, therefore Shirvai said, constitute a bench of 3 judges to decide what is decided by 13 judges. Churning out the ratio decidendi is not a small thing. It becomes very difficult. What the point? Then I was saying about that Hindu marriage case. Question is the validity of the Hindu marriage. There the court will discuss what is the marriage principle amongst Muslims, nikah, muta marriage, marriage for one sexual intercourse, marriage for a day, marriage for a night, children begotten or legitimate children. 5G's outlines of Mohammedan law, Mullah's Mohammedan, Muslims Mohammedan law, they discuss about this. Suppose in a Hindu marriage case, something is said about the Muslim marriage, Parsi marriage, Christian marriage. That was not the issue. Therefore, that becomes obiter dicta. Got the point? Obiter dicta is something, it is opinion of the court on the points that were not required for adjudication of the case at hand. The case related to Hindu marriage. You spoke about the Muslim marriage, Christian marriage, Parsi marriage. Parties were not Parsis. There was no issue relating to this. But still Supreme Court, Hon'ble, the highest court of the country will say something. In Australia, High Court is the highest court of Australia. In England, House of Lords was now the Supreme Court itself. Okay? The highest court of the country says something on points that were not essential for adjudication of the case at hand. That becomes obiter dicta. Amongst Muslims, the tying of Mangal Sutra is not necessary. Suppose we hold that way. That becomes obiter dicta. what is the status of obiter dicta? On this, opinion is divided. Rupert Cross is of the firm opinion, obiter dicta is a destitute of precedential value. The courts need not follow it. But in India, there are judgments which say, which Basu discusses under Article 141 of the Constitution. D.D. Basu, Dr. D.D. Basu has discussed about it under Article 141. He says, obiter dicta of the Supreme Court is entitled to highest respect. I may have highest respect for Mr. Bose, but I may not agree with him. With that highest respect, does it mean I will say one sentence, I have great respect, greater respect, greatest respect for this opinion, but I will not follow it. There are some judgments. There is another set of judgments which say that even obiter dicta binds the courts. Other set of judgments. There is one very important judgment. Barkatullah versus Rudramurti. You can see it in your Google 95, 96 judgment of Supreme Court, where the three judgments headed by Justice Rajendra Babu said, Article 141 is not founded on doctrine of precedent at all. Because Article 141 of the Constitution says, law declared by the Supreme Court. It is not founded on doctrine of precedent. That's the lone judgment which I have seen in the constitutional law by D.D. Basu, M.V. Paili, and by Sirwai. A.B. Datar's, Mr. Arvind Datar's, A.P. Datar's commentary also I saw. He has not said anything about it. That's the lone voice of the Supreme Court. But Supreme Court, the Article 141 says, law declared by the Supreme Court. It does not say, law repeatedly declared by the Supreme Court. One single judgment may become the law. Although Aristotle said, one sparrow makes not the summer, which Shakespeare quoted in one of his works, I do not remember, which may be in Hamlet or the Adonis and Venus, I do not remember. But one single judgment of the apex court becomes the law. But then we are going to the precedent which suffers from the voice of sub silentio. Per incuriam. Suppose a judgment is rendered by the law laying down court. I am using the word law laying down court because High Court and the Supreme Court alone will lay down the law. There is no corresponding article to 141 so far as the High Courts are concerned. But courts have said under 215, 226, 227, 228 of the Constitution, the law declared by the High Court will be binding upon the people in that particular state, in its jurisdiction. When Bombay High Court in Mithu versus State of Bombay, Bombay High Court has struck down section 309, suicide, where attempt to suicide was an offence under IPC. These are offences. Maybe Brother Behera will be able to say that. I don't have much exposure to criminal law except that outlines of criminal law by Kenny's outlines, Sweet and Maxwell's publication, etc. and Maxwell, the Glanville Williams, except that I have not read any law on criminal side. Therefore, there it was struck down. Many people used to travel to borders of Maharashtra and used to try for committing suicide. If they remain alive, if the attempt becomes abortive, they are punishable. Attempt to suicide is an offence, but commission of suicide is not, because the person who commits perpetrator is not available for being tried and punished at all. People used to travel to Maharashtra, where it was a safe place to attempt to commit suicide, because they had the fear in the event the suicide does not happen, we should not be prosecuted. So the law laid down by the High Court is confined to its territory. Then from that we have moved. We were taught in the law school by Professor Sheshadri, Professor Vishweshraya. They had taught me that law laid down by a court, High Court, is persuasive when it comes to other High Court. courts. When it comes to other high court, it is persuasive. I need not agree with full bench judgment of Madras High Court. Orissa High Court may not decide that. The other high courts may, no. We only use a sentence. We respectfully disagree with the views of Madras High Court. We may not give reasons also. Then little difference is brought about by judgment of the apex court in Kusum Ingot versus so and so, where the Honorable Supreme Court said, you can look into that. Pasayat may be knowing that Kusum Ingot versus so and so, I think 2094 or I do not exactly remember, where it said, where one high court judges central legislation, then its judgment is ordinarily binding upon other high courts. So the idea of persuasiveness is to great extent can you get that Supreme Court, which is that judgment?
Which was the state of Punjab?
The state of Punjab. That Kusum Ingot is a very famous judgment. On that there is one view of Justice Mr. Fali Nariman. He said that offends the principle of federalism. Every state high court is entitled to decide the matter in its own way, and it is not bound by the decisions of the other high courts. There are such judgments. There is another problem now. Suppose I render a judgment without noticing Brother Behera's judgment on a particular point. He has already decided what should happen in a given fact matrix, and that judgment I do not notice, or it is not brought to my notice. We will generally, judges are very, very wise people in a way. We will always say, the counsel for the petitioner did not bring this decision to my notice, as if it is only the duty of the bar and judge need not know any judgment, any law, etc. Anyway, whether he brings to my notice or not, whether I notice it or not, my judgment in variance with the judgment of Justice, Honorable Justice Behera, Brother Judge Behera, is a per incuriam decision. A single judge of a high court cannot disagree. He can disagree, but the procedure is he has to refer it to the Honorable Chief Justice, saying, there is already this view, but I do not agree with this view. Therefore, constitute a larger bench that will resolve. I say X, Mr. Behera says Y. The difference now is X or Y, or it may be Z also, we don't know. The larger bench will decide that. Got the point? This has happened even in the Supreme Court. What is fee? What is tax? What is essential religious practice? On this point, there are many aspects, but only two I am giving, because Mr. Nariman wrote in 1992 Indian Bar Review, the mounting inconsistency in the Supreme Court. The heading of that article, Indian Bar Review article, is there. Mr. Panda might have seen that article, I do not know, where Nariman said the mounting inconsistency in the Supreme Court. Because Supreme Court, unlike in America, Supreme Court, all the judges of the Supreme Court will sit together. There is a famous book, 9 Scorpions. Judges in the US Supreme Court, each judge was called as a scorpion. I do not know whether you all call judges as snakes. Anyway, nobody has at least openly said it in court. Would have been very happy had anyone said about that. There they sit together and they lay down the law. There are dissenting opinions. Then we go by majority opinion. Dissenting opinion is there. Different opinion is there. Concurrent opinion is there. The consensual opinion is there. That again is a bigger topic. again is a bigger topic. If you go on chanting the songs and the introduction of all guests present in the hall and starting the function after 30-40 minutes over after the given time, all that cannot be done. It should be indoor meeting. It should begin with a sharp time. Only relevant things should be spoken. Then it becomes meaningful. Otherwise, it will be a theatre, cinema theatre, where you will be entertained without a ticket. That if you enjoy is all right, but that is not the object of this session. Object of this session is written in the invitation card. Invitation card is an invitation to you, but mandate to the speaker. The speaker has to comply with the mandate, because it is an open assurance to the people that I am speaking like this today. Justice Krishna Dixit is speaking. I should go. I should hear. I will not agree with him, but I will hear his voice. With that many people come. If I go on saying something else on Natya Shastra, I can, but that is not the mandate. Okay, then with this, to which part we should, I said judgment sub silentio. Suppose I render a judgment without noticing Odisha Irrigation Act, without adverting to particular provision in the Odisha Education Act 1969, the Orissa Urban Development Authorities Act 1982, I do not adhere to important provision. The English judges and English jurists like Jeremy Bentham, Holland, they said it is a judgment sub silentio. It binds the parties till it is set aside by the higher court, or in review or appeal, revision, as the case may be. But it does not have precedential value. It cannot be cited to bind the hands of the judges. What is the point? If a judgment of court, just Behera's judgment I ignore, then it becomes judgment per incurium. What's the point? Then I covered ratio decidendi, judgment sub silentio, per incurium, obiter dicta, now passing observation. I will take that Hindu marriage case now between A and B. The court says, amongst Muslims this is the procedure, amongst Parsis that is the procedure, amongst Jehovah Witness this is the procedure, amongst Jews it is the procedure. Now I will say, in America, there can be marriage between two men or two women. Is it the part of the dispute? Muslim law I can understand because we have Muslims. Parsi law, yes, we have Parsis. There are Parsi marriages. Christians, yes, we understand. They are part of this country. Therefore, to some extent, what are the customs prevailing in that community? I may be justified by way of comparative jurisprudence. But if I travel beyond the frontiers of the country, I go to African continent and decide how in Tanzania the marriages are performed. That becomes a passing observation. What is a passing observation? There are two judgments. One is of Calcutta High Court, Rajasthan High Court, and another is by Bombay High Court. One famous judgment by Justice M.C. Chagla, the great Chief Justice of Bombay High Court. His autobiography, Roses in December. One of the best books which you will see that. So this is the bird's eye view. It is a very small little bird's eye view. It is not the owl's eyes view. Owl is it is not the view of ostrich. It is the eye view of tiniest of the birds which I see when I go for morning walk in my quarters, in the lawn of my quarters. Very tiny. They are so tiny, I get confused. Is it an insect or a bird? That bird's eye view I have put forth before you. Thank you for your patience.
Thank you, my lord. Nothing could be more lucrative, more elaborative, even though it's a bird's eye view in lordship's view, but it is definitely an eye-opening for all of us. As my lord has directed, and we have also heard in detail, so I would love to come to the floor, and any questions, especially my lords have stated that questions from young lawyers would be appreciated, and as it is said that tad vidhi pranipatena pariprashnena sevaya upadekshantite jnanam jnanina tattva darsina. Following the same principle, with the permission of the chair, we would love to have some questions and answers from our erudite speaker.
And question should not relate to what you are going to decide in my case tomorrow. It is still raining outside. You cannot go. So therefore, unless we had one English poem. Rains go away. Little Johnny wants to play. Come again, something like that. When I was this one, so it's raining outside. You are bound to ask questions now, or else you will get wet in the rains. No questions at all. Then we'll ask them to come and speak about the further topic if they don't have any questions. These questions are for the youngsters. Many questions will be lurking at your mind, but for one or the other reason, articulation is not possible, or you have little withdrawal symptoms. Therefore, if you ask a question, the doubt of many may be dispelled.
There is one question.
Yes.
Well, while we are preparing a petition before filing, sometimes what comes to mind, it's a very practical, might not be very important for all of us, especially for the seniors.
Yes.
One thing comes to mind, how is the judge, whether the judge will look at the precedent first or the honorable judge will look at the facts first. So as a young lawyer, we are confused while preparing the brief, especially drafting it. What is in general important, whether to draft it in consonance after researching elaborately on the precedent, or presenting the fact, then go for the precedent.
Suppose if your case is founded on custom, still you will go to precedent. No, it all depends upon someone. Therefore, very often I tell to read Holland's jurisprudence, Solomon's jurisprudence. There is Hoffel's trapezium. Hoffel, a great lady, I think of Holland, Shri, I do not remember. She has given a chart. Right duty, Hoffel, just see that. Right, she calls it a jural correlatives. Under that heading, even Salmon discusses it. Holland discusses it. And Julius Stone discusses it. Right duty. If I have a right to my reputation, what is meant by that? I have right not to be defamed. Corresponding duty lies with the world at large. Okay? Therefore, you come to court not for singing. You come to court to complain the breach of your rights. If you go to fundamental rights, part 3 of the Constitution, you will say the state and its instrumentalities as given under Article 12 of the Constitution, they have breached my right. What is your right? Right to publish a research thesis, the right of a convict. Sajgiri versus State of Maharashtra. A person was convicted and he was serving the sentence. He wrote a book on atomic theory in the jail. He wanted to publish it. The jailer said no. he filed a writ petition. My right to speech and expression is not silenced by the conviction order. Supreme Court said yes, 19(1)(a), right to speech and expression. But therefore, you should know your rights, right, duty, authority, immunity, liability, and corresponding is one more thing. There are totally 8 items are left. Disability is there, immunity is there. Client. That way, that happens because law, like literature, is a perception. It's a perception. But still, broadly, you can know what is law. Therefore, Oliver Wendell Holmes used to say, law is what a bad man thinks as to what the judge is going to do in his case. He never bothered about the Austinian notion of law at all. He said, Justice Oliver Wendell Holmes, he said, law is what a bad man involved in the case thinks as to what the judge is going to do in a given case. You should also know there are judges, pro-labor judges, pro-women judges, pro-tenant judges, pro-tiller judges. It's a practical matter. We are all human beings. We are our experiences shape our notions, our beliefs. Therefore, you should exercise lawyer's diligence when filing the case and getting it posted before particular bench. That's also very important. Yes, you can.
Patience is the best criteria of an advocate. Different judges will want different type of applications. They may differ from person to person. Your perception should not be different from them, because for some time, for some year during the tenure of a one judge, you may not get relief. But you should not be wayward from your path. What is your thinking? You should stick to the same. Because judges are not every time you will hear there. You will for the client. Your motto is to give benefit to the client, for which you should not bother about their perception. They may think, because in judgment writing system, there is no system how a judgment will be written. As per law, judgment is written for the common people. The judgment should be understood by the common people. But sometimes different judges are writing different nature of judgments. Someone is starting from a shulko, someone is giving description, someone is giving para-wise comment, like. Then you should not bother about this, because judgment right is no definite system, for which the writing of judgment will differ from person to person. Some judge will be technical in nature, some judge will be giving substantial justice to the parties. Then the patient of an advocate to make tolerate them is the best criteria. There is no other than criteria for an advocate to make any application. You bound to tolerate, because you have nod your hand into that situation, you will tolerate them. Inside the court you will praise them, outside the court you may not praise them.
Once Dabthari was asked, he was in England. Every vacation he used to go abroad and came back to the Supreme Court on the reopening day. A judge commented, Chandulal Dabthari has come, let us ask him. Mr. Dabthari, what is that concept of justice? He said, my lord, my case is serial number 9 in today's list. An order in my favor is the justice. What is justice again? Big topic. My brother Behera said you should tolerate, but how long? Even the toleration is, there is a limit for toleration. At least the cases should be decided as a concession to the shortness of human life within one life, without need of bringing LRs on the record at all. There should not be question of bringing LRs of the deceased on record. Cases should be decided. We decide the divorce matters. You take it for 15 years. After endocrinology of the body fails, whether you grant decree, you deny decree, what difference it is going to make? We have to keep in mind the endocrinology of human body. Otherwise, justice, that is the reason. In fact, in 1215 Magna Carta, the one of the stanzas said, to none shall we delay, to none shall we deny, to none shall we sell justice. 1215. Do not delay, do not deny, do not sell justice. What is meant by that? Just arguing, hearing, and again postponing. How long? And the cases, very small case. He has lost his cow. It happened. One buffalo was lost. Two persons came and took away buffalo. Then a question arose whether one best example, one instance I am giving you from Uncommon Law by A.P. Herbert. A small villa on the on the bank, on the seashore. He calls it as a Padim Magna. The whale came, it was washed ashore, and people were very happy. Oh, huge whale, Timingal. Many days we need not go for fishing at all. This will cater to the village for months together. How long it will remain undecaying? They did not know. On the third, fourth, fifth day, the foul smell of decay started spreading in the village. And they made a petition to the government, to the Gram Panchayat, something body like that. Whale is decaying, it has become very difficult for us to reside here. Kindly remove it. They sent it to government. Government animal husband, the fisheries department, they sent it. Fisheries department kept the representation pending for 15 days. When people like you filed a writ petition for consideration, which you will do, number of cases we make, consider. What consider? Then they said whale is not a fish, therefore we have no jurisdiction over the matter. Your representation is rejected, with liberty to approach concerned department. They went to animal husbandry. They said, though whale is not, in biological term, zoological term, it is not a fish, but anything that resides within the water is treated as a fish only, therefore you should take it back to the fishery department. They went to the chief secretary. Chief secretary said, let us take the opinion of the Attorney General. Attorney General sent the letter saying that I am not the student of zoology at all. I will refer this matter to some college of fisheries and animal husbandry university. We will have their opinion. By that time, the whale was completely decayed and it had only its skeleton. Very thick bones. The people took those bones, made some statues and started selling them in the London 10 Downing Street. And Rajabhatas came saying, anything in the sea belongs to the Queen. How could you take it? You should be prosecuted for that. This is how the case ran in A.P. Herbert's Uncommon Law. Very witty writer. Very witty writer. Yes.
Thank you, my lord. Now, before taking any questions, may I request my lord Honorable Justice?
Yes, one second. Yes.
I led myself Basudeb Mahapatra,
Ah.
working and advocating Odisha. If the Lordship may permit, I will ask you one question. What is the difference in between an acquittal and honorary acquittal?
Yes. Honorary, right? Honorable acquittal.
Honorable acquittal.
Generally, the criminal case begins, as a civil case begins with a plaint. Plaint is not defined in CPC. Section 25 CPC says, a suit is instituted by the presentation of the plaint. Similarly, in criminal law, the criminal case is instituted by the present lodging of the FIR or filing of the private complaint under section 200 of CRPC. Under the new legislation, I do not which is this section. Where the court, after looking into the matter, takes cognizance of that, issues summons to the accused persons. Accused appears. Then the charge is ordinarily framed. Once a charge is framed, ordinarily there is no cut short. Matter has to go for trial. This is what Apex Court said in Hardeep Singh versus so-and-so 2013 or 14 judgment. Where there is absolutely no case at all for the prosecution, then it is called honorable acquittal. There is famous judgment of Supreme Court, Ramlal versus so-and-so, 2021 Supreme Court. There is another division bench judgment of our Karnataka High Court, P.V. Rudrappa versus State of Karnataka. We have laid down 5 propositions when an acquittal in a criminal case is honorable acquittal. Where absolutely no evidence, because the judges, the magistrates and judges of the criminal court may not use the word honorable at all. What is honorable acquittal is not stated in any of the statutes. It is a judgment law, completely judgment law. The first judgment is of 1933 in England, House of Lords judgment. From 1933 to 2021, Ramlal versus so-and-so, what is honorable acquittal is mentioned. Honorable acquittal concept operates in service law. It relates to reinstatement, recovery of the wages, salary, promotion, etc., etc. That is how it is treated. Therefore, those who practice on civil law should also know the service law. Those who practice on criminal law, the lawyer should be careful not only in getting the acquittal, he should ensure that honorable acquittal is granted. Maybe that he will request the judge, my client is an employee, if you say one word, honorable acquittal, based upon no evidence, then it will help me. Kindly enter that. I have not seen such submissions being made in criminal cases also. They think that criminal law is different, service law is different. All laws address men only. They do not address rivers or calendars. Is it not? Therefore, comprehensive view of law. You should not say, Jeremy Bentham says in famous The Principles of Legislation and Morals, a very famous book. He says, no lawyer, no judge shall differentiate, saying that this is civil law, this is criminal law. Bigamy, offense of bigamy, it involves law relating to marriage. Succession, suppose illegally you deprive somebody from the property. It partakes the character of an offense, it becomes the breach of civil laws. Further, this is the position.
We'll take a few more questions, but before that, as we have my Lord Honorable Justice Ananda Chandra Behera with us, we don't want to miss the opportunity of listening few words of wisdom from my Lord Justice Behera. I would like to invite and please welcome my Lord Justice Behera with a huge round of applause.
Respected my beloved senior judge, Justice Shripad, respected honorable guests on the dais, of the dais, and the honorable members of the Adhivakta Parishad and other members, ladies and gentlemen. Previously, while there were kings were deciding the cases for the people. People were ordinarily respecting them. Everybody had a belief that what the king will decide, that will be accepted. He is very impartial. Thereafter, the system of judges came. Judges, magistrates decide the cases of the people. Everybody has a respect that whatever they are deciding, that is for the benefit of the society. The law has been prepared for the benefit of the society. Society is not for the law. Always any judgment, any law should be marked with the necessity of the society. If any judgment or decision or law will not meet the necessity of the society, that will not be accepted by the people. Because law is for the society, society is not for the law. Therefore, the advocates and judges always should keep in mind that the judgment or the cases should be decided which should be beneficial for the society. Whenever the people will think that any judgment rendered by a court is neither benefit of the society nor benefit of any general public, people will lose faith on the judiciary. Why we are following the precedent? What is the meaning of precedent? Precedent means like cases are to be decided alike. If similar situations, the High Court or Supreme Court have given decision, we shall follow the same, apply the present case. But sometimes the precedent may not be fit to your case, for which it should be the duty of the judge or it should be duty of an advocate to create a situation. The extraordinary situation will create extraordinary law. Always the precedent may not be befitting for a particular case. In 77 criminal law journal, there is a decision because in a kidnapping case. In that decision, judgment, the accused was acquitted by applying the precedent of Dwapara Yuga. Arjuna Subhadra kidnapping case. Because in a kidnapping case, lawyer could have convicted a person. That matter went to the Calcutta High Court bench, one judge was deciding. There was a cross-examination. Whenever the both were going, girl and boy, the girl was moving ahead and behind him, the boy was moving behind him. For which he applied the precedent of Dwapara Yuga. Because whenever Balaram had went to teach Gada Juddha to Duryodhana, at that time by the instigation of Sakuni, he had committed that Subhadra will marry Duryodhana. But Sri Krishna was very much interested to give marriage his sister with Arjuna. And returned from there and expressed the matter before Sri Krishna that I have committed the marriage of Subhadra will be solemnized with the Duryodhana. For which Sri Krishna immediately sent a message through Rukmani, you tell Arjuna to take Subhadra. Immediately Arjuna takes Subhadra in a chariot, in a ratha. And chariot was moving, some men came, intimated Balabhadra that Arjuna is kidnapping Subhadra. Then Balabhadra became angry and he will not alone go, came to Sri Krishna and asked him, let us go, you shall kill him. At that time, Sri Krishna, very clever, he sent a message, you tell him, you will rope of the chariot will be catched by Subhadra by the time of reaching, and Arjuna will set in the chariot. Immediately both the brother move and saw that Subhadra is handling moving the chariot, Arjuna is sitting there. At that time, Sri Krishna told him, you see, Subhadra is kidnapping Arjuna, Arjuna is not kidnapping. By applying that ratio, acquitted the accused, because gun was moving ahead. So, precedent was there. We shall follow, apply the precedent in the right stage. Because anybody, the judges should be, the judges or advocate, all the advocates should have passive tolerance. Like Vasishtha, not like Vishwamitra. Because Vishwamitra had gone to teach everything, learn everything. Whenever he came before the Vasishtha, Vasishtha never responded him as Brahmarshi, always Rajarshi. Then again, went to teach, came. Every time Vasishtha asked him as Brahmarshi, for which Vasishtha has patient, for which he decided to make a Jogya, Vasishtha Marana Jogya. Created a Jogya, Vasishtha Marana Jogya, and Vasishtha became the Purohit of the Jogya. He did not deny to be a Purohit. If 3 times he will pour the Ghyo in the Jogya, he will expire. 2 times he poured. Last time, when he was going to pour, at that time Vishwamitra thought, why he is not impatient? At that time he caught his hand. Then Vasishtha told him, Brahmarshi. Advocates should like character of Vasishtha. Because many judges will come. Different mentality judge will come. But your character should like Vasishtha, you will tolerate them. Or else your profession will be hampered. Because the judges are deciding case from their mindset. You think from which family, which character, which instinct they are coming. Their mentality should be like that. The decision you should not expect from everybody similar type of judgment. There may be discrepancy in the judgment. You should not always blame them, because if you will be judged, your mindset will be separate. For that reason, the advocates will mix with everybody. They have the capacity to how to maintain them. A good advocate who will maintain them, he will be successful. So for that reason, this is Adhivakta Parishad. My opinion is, when the advocate should be such a straightforward and front, discrimination should be stopped. Anyhow, they will try how the discrimination will be minimized. Because technicality and substantial justice are different. Always some judges are moving for technicality without rendering substantial justice. You follow certain procedure, you file a separate application, you move to the lower court. If they have capacity to decide the case there, unnecessary remanding them to lower court, that is an unnecessary burden. Not that the judgment will not benefit for the society. I had a rendered a judgment. My brother judge, a learned advocate who had filed the application, has said here. I had written in that judgment, the law is for the society, but the society is not for the law. Because one person had executed a gift deed, giving stamp of 1,44,200. That gift deed was not registered, for which he wanted to return back the stamp duty. The sub-register sent him to approach the collector. Collector, in its order, passed an order that you may take the e-stamp duty of same value. That man's age is 90 years. If he will take back the e-stamp duty of same value at the fag end of his life, and the question of utilization of the same in another place by executing any document does not arise, for which the judgment should be practical in such a nature which will be benefit for the society. My senior judge told everything about the Precedent. He is the good orator. I have no idea about this. Then my feeling is the Adhivakta Parishad, all the members of Adhivakta Parishad, their works and activities should be such a nature how the discriminations will be minimized, because the technicality will not give any benefit for the society. We shall give with always for the practical. The applications of every person may be similar, may not be similar, but the relief should be based on the same. How the persons will get benefit. There may be sometimes the precedent was made by looking to the that situations of society, but that precedent may not be applicable here, for which the judge or advocate should distinguish the precedent and should express that the precedent which was relied upon by the party, that is not befitting for the present society. Therefore, always the applications, arguments and judgments should be practical in nature. I am telling one thing about NI Act, MACT case. NI Act, some judges are giving punishment without compensation, without fine. Some are with not punishment, compensation. Some are only compensation without punishment, without fine. Different categories of punishments, our compensation are coming from them. There is no uniformity in India how that will be streamlined. Some judges are giving fine, some compensation, some other things, like MACT cases. If one person provided compensation for a hand fracture, 20,000, one is providing 1 lakh. So my view, the corruption percentage may be some less, but there should be acceptable by the public. The PC must be acceptable by the public. That is good for all. There may be PC, but the PC should be such a nature which could be acceptable by the public. If the PC will be more than the sanction amount, or substantially with the sanction amount, then how the society will run? Then I shall not tell nothing more. Now I am in case of whenever state is a party, if the case of a citizen is genuine, in that case state should not grumble to provide the relief to the citizen if citizen comes in late. Because in 1954, MC Chogla Justice, Bombay High Court, Chief Justice had written a judgment that law of technicality, the state cannot take the plea of technicality to defeat the legitimate right of a citizen, for which in such a situation the state should be very prompt and forward without sacrificing, without giving any benefit to the state. But if state will not belong them, then he should freely accept the cases of the citizen. The judge should be like that, because seeking any future appointment, he will sacrifice the case of the citizen. That is also bad for the society. So the judge advocate should be independent, should be straightforward, should be front, by which society will be benefited. Thank you.
Thank you, my lord. My lord, it is said that Namanti Falena Bruksha, Nambranti Gunina Jana. I think the two of the honorable judges who have adorned the chair as the guests of this symposium are the best example of such line. So we are really indebted. We started with a bigger view, a world's view on the doctrine of precedent, and we ended with a view from Bharatiya Jnana Parampara from my Lord Justice Behera. Now I would request the President of Adhivakta Parishad Odisha to shortly conclude the session, then we'll have vote of thanks. May I request the President?
सम्मान्य विचारपति द्वय आजिर यही सभार आम यूनिट्र सभापति संपादक राज्य साधारण संपादक भौणी नायक एवं आगे बसी ज्ञानी गुणी वरिष्ठ अधिवक्ता माने भाई माने भौणी माने दुई जन बहुत बढ़िया वक्ता एवं जो व्यवस्था रे आम काम कर शुणी सारा मु भावुचे आ किसी कहबार ना किंतु अधिवक्ता परिषद प्रतिष्ठा दिवस होता कारण एवं अधिवक्ता परिषद राज्य सभापति दायित्व थिबा दृष्टि दुईपद निश्चित आपण मान पाखे रखी जो अधिवक्ता परिषद 1992 मसीह जितेबले माननीय दत्तपंत ठेंगड़ी द्वारा प्रतिष्ठा है से आम भितर अनुप भाई अनुप बोस जहाँ को बुलबुल दा बोली समस्ते साधारण भाव डाकुचे से उपस्थित थे प्रथम से आसला 93 मसीह पुरी रे गोटे राज्यर सब ओडिशा एवं मत लगुच बोध हुए वेस्ट बेंगल मिसेकी गोटे सभाटे करते जो परम पूजनीय शंकराचार्य आसिक उद्घाटन करते। तो आज आम बहुत कथा शुणा मु 2 मिनिट भीतर सब सारी शुणा गोटे वशिष्ठ उपाख्यान शुणिले तो ये अधिवक्ता परिषद वशिष्ठर काम कर चली वशिष्ठ मान भितर आमे माने समस्ते सामिल होचे धैर्यर सहित दीर्घ दिन धरी कार्य कर चली समस्ते उद्देश्य रही जे समाजर शेष वर्ग रे व्यक्ति को भाव में न्याय पाइब लास्ट पर्सन जी अच्छी पाखे केमती न्याय पहुँचो से अधिवक्ता परिषद वशिष्ठ रूप में काम कर चलती दधीति रूप में दान कर चली एति मात्र कहि आज जो युव बंधु माने जो वकील बंधु माने आम सांगे उपस्थित अच्छा से माने राष्ट्रवाद व्यवस्था को आम समस्ते जानिबा शुणिबा ये जो अधिवक्ता परिषद जानापी आज मु अनुरोध करी आमर देवाशीष भाई को जे गोटे बुकलेट आम तैयारी करके आज दबा आ जो बुकलेट समस्त पाखे पहुँचब आ समस्ते जानीपर जे अधिवक्ता परिषद केबे को भली भाव में तैयारी होता बा गठन होता आभली भाव में आज पर्यंत काम कर आसी आम पाखे आज जे आम अधिवक्ता परिषद प्रतिष्ठा करते आम ऑनरेबल जस्टिस शुणिले जे सहित बहुत बंधुता थिला दत्तपंत ठेंगड़ी विषय आम समस्ते जापर महान चिंतानायक और जहाँ को सारा विश्व विभिन्न प्रकार आईन तैयारी करथिबा कारणरू एवं व्यवस्था तैयारी करथिबा कारणरू समस्ते जानुचंती। तो आज दिन में ये अधिवक्ता परिषद प्रतिष्ठा दिवस रे पुणी समस्त को आउरी थरे स्वागत करुछि अभिनंदन जनाऊँचे आमे जो भली भाव में सारगर्भक कथा शुणिले मु भावुचे अनेक दिन धरी जेते जेते सभा होइछि ये सभा संपूर्ण किसी नियारा थिला दुई आमर जो ऑनरेबल जजेस मान वक्तव्य आम अनेक किसी जिनस शुणिले जानिले जो आम मानकर प्रैक्टिस रे मध्य बहुत काम दब सीटा हूँ गोटे बड़ कथा अधिवक्ता परिषद रे एभली जो आम न्याय केन्द्र करुचे जो आम सिम्पोजियम सब विभिन्न समय करुचे आमर
Honorable Justice A.C. Behera आगुरी कही जेबे जेबे ये सिम्पोजियम किसी कर शिक्षा प्रक्रिया व्यवस्था विषय मु तुम पाखे पहुँची पुणी आज आउ थे दुई जन जाक जजेस मान अनुरोध करी आम अधिवक्ता परिषद विभिन्न कार्यक्रम समय आम मान समस्त को यह भाव आईन विषय एवं सामाजिक स्थिति विषय जुडिशियरी व्यवस्था विषय पुणी समस्त को अवगत कराइबे आईनगत भाव में आम समस्त को बुझेबे जिते समय आम देले आम से तो समय जति धन्यवाद देवा बहुत कम हम शेष में निश्चित भाव में राज्यर सभापति हिसाब से दुई ऑनरेबल जजेस मान को अंतर कृतज्ञता जनाऊँगी धन्यवाद तो देवी ना कृतज्ञता जनाऊँगी और आगामी दिन में आम ये सहयोग करेंगे आशा रखुच्छी बाकी अवशिष्ट अल्प समय आम साथ
Thank you, sir. Although I feel that none of us wish to conclude this session because we have in fact dived into the ocean of the concept, then we had a huge various topics and various angles to the topic, starting from a global view to Bharatiya Gyan Parampara. But as time is running away, so I would request Sri Jateshwar Naik, Secretary Odisha High Court Unit Adhivakta Parishad, to propose a vote of thanks.
Jai Jagannath. Respected Chief Guest, Honorable Justice Dixit Krishna Prasad ji, Honorable Judge of the Odisha High Court, and the guest of honor, Honorable Justice Ananda Chandra Behera, and the Chief Speaker, Shri Pitambar Acharya, Advocate General of Odisha, Shri Ajit Patnaik, State President Adhivakta Parishad, Shri Rudra Prasad Kara, Senior Advocate and the President of Adhivakta Parishad High Court Unit, and Shri Devashish Tripathi, State Secretary Adhivakta Parishad Odisha, and Ms. Pratima Nayak, Joint Secretary Odisha High Court Unit, esteemed guest, fellow advocate and dear participant. It is my privilege and honor as Secretary of the Odisha High Court Unit to extend our heartfelt gratitude to all who have contributed to the success of the two-day symposium on Young Advocate and Doctrine of Precedent challenge I had. First and foremost, I wish express profound thanks to our Chief Guest, Honorable Justice Dixit Krishna Shripad ji, for sparing valuable time from judicial duty to inspire and enlighten us with a thought-provoking address. Your citing into the doctrine of precedent and in the relevance of young advocate will act as a guiding light for all present. And also, I must thank to our very lovely judge, Honorable Justice Shri Ananda Chandra Behera, they are also sharing their valuable time and they are enlightening us and they are teach something. What is our duty of the lawyers? Have patience. That is the very motto, that have patience. But we do not understand what is our limit of the patience. That is the true difficulty. Our sincere appreciation goes to Shri Pitambar Acharya, Advocate General of Orissa, who has graciously accepted our invitation and delivered the keynote address. Your word have added immense value to our understanding to the theme and motivated the immense legal community. I also thank Shri Ajit Patnaik, State President Adhivakta Parishad, for sharing his vision and leadership, and Shri Rudra Prasad Kar, Senior Advocate, President of the High Court Unit, for the warm welcome and tireless support of the organization in this event. And also thank to Shri Devashish Tripathi, State Secretary. They are organizing all these things and and we also thank our Joint Secretary Madam Nayak, Pratima Nayak, They are also present in this occasion. We are all grateful to our speaker, moderator and participant enriched today discuss and to the organization team for their meticulous planning and executing the agenda. For encouraging our guests, the ceremonial lamp lighting and the vibrant question answer session to the closing area. I thank learned advocate, senior advocate, law student, print media, personnel and support staff, including police and others, they are supporting and help for this event. Finally, I extend thanks to every member of the Adhivakta Parishad, support staff and volunteer whose dedication and the teamwork have shared the program into the memorable evening. And thanks all, and I request one thing, we have some arrangement to some tea break, so I will request all the members, they can participate in our tea break. Thank you all. The meeting is closed. Now we are requested all the members to stand and we start the national anthem, Jana Gana Mana. Jana Gana Mana Adhinayak Jaya He Bharat Bhagya Vidhata Punjab Sindhu Gujarat Maratha Dravida Utkala Banga Vindhya Himachal Yamuna Ganga Uchala Jaladhi Taranga तब शुभ नामे जागे तब शुभ आशीष मागे गाए तब जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे भारत माता की भारत माता की भारत माता की वंदे वंदे वंदे। The meeting is closed.
I like the chocolate.